united, there is little we cannot do.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Welcome back to another episode of Freedom Friday by Uncommon Sense. I'm your uncommon host, Butch, and today, what I just read, these are one of our rights, and a lot of people don't realize that. And this is the Fourth Amendment, for those that don't know. But I wanted to go over the Fourth Amendment because this means a lot to me. A lot of people think that this means one thing, but I just read to you exactly what it says in the Constitution. And now I want to give you a little historical background on the Fourth Amendment and how it came about and how we have it here in the United States. Few provisions of the Bill of Rights grew so directly out of the experience of the colonials as the Fourth Amendment, embodying as it did the protection against the use of the writs of assistance, but though the insistence on freedom from unreasonable searches and seizures as a fundamental right gained expression in the colonies late and as a result of experience. There is also a rich English experience to draw on. Every man's house is his castle was a maxim much celebrated in England. Salmon's case, demonstrated in 1603, a civil case of execution of process. Salmon's case nonetheless recognized the right of the homeowner to defend his house against unlawful entry, even by the king's agents, but at the same time recognized the authority of the appropriate officers to break and enter upon notice in order to arrest or to execute the king's process. Most famous of the English cases was Entick versus Carrington, one of a series of civil actions against state officers who, pursuant to general warrants, had raided many homes and other places in search of materials connected with John Wilkes' polemical pamphlets, attacking not only governmental policies, but the king himself. Entick, an associate of Wilkes, sued because agents had forcibly broken into his house, broken into his locked desks and boxes, and seized many printed charts, pamphlets, and the like. In an opinion sweeping in terms, the court declared the warrant and the behavior it authorized subversive, quote, of all the comforts of society, unquote. And the issuance of a warrant for the seizure of all a person's papers rather than only those alleged to be criminal in nature, contrary to the genius of the law of England. Besides its general character, the court said the warrant was bad because it was not issued on a showing of probable cause, and no record was required to be made of what had been seized. Entick versus Carrington, the Supreme Court has said, is a great judgment, one of the landmarks of English liberty, one of the permanent monuments of the British Constitution, and a guide to an understanding of what the framers meant in writing the Fourth Amendment. In the colonies, smuggling rather than seditious libel afforded the leading examples of the necessity for protection against unreasonable searches and seizures. In order to enforce the revenue laws, English authorities made use of writs of assistance, which were general warrants authorizing the bearer to enter any house or other place to search for and seize prohibited and uncustomed goods, and commanding all subjects to assist in these endeavors. Once issued, the writs remained in force throughout the lifetime of the sovereign and 6 months thereafter, when, upon the death of George II in 1760, the authorities were required to obtain the issuance of new writs. Opposition was led by James Otis, who attacked such writs on libertarian grounds, and who asserted the invalidity of the authorizing statutes because they conflicted with English constitutionalism. Otis lost, and the writs were issued and used, but his arguments were much cited in the colonies, not only on the immediate subject, but also with regard to judicial review. The language of the provision that became the Fourth Amendment underwent some modest changes on its passage through the Congress, and it's possible that the changes reflected more than a modest significance in the interpretation of the relationship of the two clauses. Madison's introduced version provided the rights to be secured in their persons, their houses, their papers, and their other property from all unreasonable searches and seizures shall not be violated by warrants issued without probable cause, supported by oath or affirmation, or not particularly describing the places to be searched, or the persons or things to be seized. As reported from committee with an inadvertent omission corrected on the floor, the section was almost identical to the introduced version, and the House defeated a motion to substitute, quote, "and no warrant shall issue," for "by warrants issuing," in the committee draft. In some fashion, the rejected amendment was inserted into language before passage by the House and is the language of the ratified constitutional provision. As noted before, the noteworthy disputes over search and seizure in England and the colonies revolved around the character of warrants. There were, however, lawful warrantless searches, primarily searches incident to arrest, and these apparently gave rise to no disputes. Thus, the questions arise whether the Fourth Amendment's two clauses must be read together to mean that the only searches and seizures which are reasonable are those which meet the requirements of the second clause, that is, are pursuant to warrants issued under the prescribed safeguards, or whether the two clauses are independent, so that searches under warrant must comply with the second clause. There are reasonable searches under the first clause that need not comply with the second clause. This issue has divided the court for some time, has seen several reversals of precedents, and is important for the resolution of many cases. It is a dispute that has run most consistently throughout the cases involving the scope of the right to search incident or to arrest. Although the right to search the person of the arrestee without a warrant is unquestioned, how far afield into areas within and without the control of the arrestee a search may range is an interesting and crucial matter.
And so, my fellow Americans, ask not what your country can do for you, ask what you can do for your country.